Now, our founding fathers, Washington, Adams, Jefferson, Madison, Franklin, knew that our freedoms and our republic would not endure without an accurately informed electorate, and that government of, by, and for the people would perish unless rooted in rotation in office, checks and balances, and a minimum amount of secrecy in the conduct of government public business. Needless secrecy in the Supreme Court justices' performance in the business of judicial government allows and encourages the abuse of the judicial powers of interpretation and discretion. That can lead to violation of the rule of law and the unjust, unprofessional, unfair, and disorderly performance of the justices' duties. Now, because Mary Beth Kelly and Bob Young and their media supporters are repeatedly misleading the voting public with incorrect assertions about their performance, temperament, and character as judges, regretfully, it is necessary that I share with the public facts, not fiction, that I learned while serving as a justice of the Michigan Supreme Court during the last 15 years. I ask you to listen and then decide for yourselves whether Bob Young and Mary Beth Kelly are fit to serve as justice of the Michigan Supreme Court. The facts about Bob Young are: 1, Justice Young has used at least one racial slur and vulgar language while performing the business of the court during regular court sessions. I do not make that statement a fact without support. I will read you the following memo that I sent to all of our justices after such his outburst. In May 2006, this memo was sent only to justices, although staff members also were present at the conferences. Here's the memo, dated May 19, 2006. This court should maintain the highest level of professionalism, decorum, and dignity in conducting the public's business. Immediately after the April 19, 2006 conference, I had drafted the memo below. I spent time deciding whether to send it. At the May 10, 2006 conference, Justice Young's use of the N-word, N, a number of doubts, S, when commenting on an announced candidacy for a judgeship during the court's discussion of commissioner report cases, confirmed the need to state the following. The business of the court should be conducted in a professional, respectful, and dignified manner. But during the conference on April 19, 2006, there were 2 instances of unprofessional and offensive conduct. Such instances of unprofessional, disrespectful, and undignified behavior, almost juvenile or locker room behavior, occurs much too often. My concerns, voiced over the years, have not succeeded in improving the situation, so I feel that the need to write to you in this manner. Justice Young's suggestion, in jest or not, that Justice Markman begin his proposed response to the State Appellate Defenders Commission with the phrase, quote, "You ignorant slut," close quote, was crude, offensive, inappropriate, and unprofessional. Similarly, the comments at the April 19, 2006 conference characterizing the trial judges as, quote, whining, close quote, about the proposals of Administrative Order 204-28, sick leave and vacation for trial judges, was cavalier and unprofessional. This type of conduct is unworthy of the justices who engage in it and of the offices they hold. I ask that all the justices thoughtfully and carefully reflect on the standards of behavior to which this court should hold itself. Perhaps everyone should imagine that the court's conferences are being televised. The public would be appalled at how this court's business is often conducted. There was no response or objection to this memo that I sent to the justices. Two, that happened in spring of 2006. You're learning about it today. In December of 2006, Justice Young, along with Chief Justices Taylor and Justices Corrigan and Markman, with Justices Kavanaugh, Kelly, and myself dissenting, adopted a gag order, an administrative order 20608. Here's what it said. This is the first page of it. I have all this documented. It's all on my website, justiceweaver.com, personally funded. This is the gag order. All correspondence, memorandum, and discussions regarding cases or controversies are confidential. The obligation to honor confidentiality does not expire when a case is decided. The only exception to the obligation is that a justice may disclose any unethical, improper, or criminal conduct to the JTC or proper authority. Note, not to the public. Now, the purpose of this gag order was to keep me from sharing with you how we conduct the court's business. The state's Code of Judicial Conduct says judges may speak about matters decided by the court. 3, on January 17, 2007, a public hearing was held on whether the gag order should be retained or amended, because the order had been adopted without following and giving proper notice to the public as required by court rules. Testimony, both for and against the gag order, was heard. The justices met after the hearing. We all met in private conference and did not vote to retain or amend the order, and the matter was passed to an undetermined time in the future. 4, beginning in 2008, Justice Young stated he would no longer approve or disapprove of any minutes of the court. This is what Justice Young said for the minutes of May 21, 2008. Abstain and refuses to approve, Justice Young, to approve any minutes until one of us, either Justice Weaver or Justice Young, leaves the court. For the next 2.5 years, 2 years and 4 months, he abstained from voting on the official minutes of the court. He didn't resume voting on the minutes until this year's September administrative meeting after I was gone. 5, in March of this year, 2010, Justice Young refused to participate in disqualification matters before the court. He had a duty to participate, and he refused to do so. He did it again in June of this year. 6, from April 21st through May 11th, 2010, Justices Young, Corrigan, and Markman refused to attend 4 consecutive regularly scheduled conferences of the court because I would not agree to abide by their gag order. Remember, this was a gag order that had not been retained. As a result of this behavior, to refuse to personally attend the conferences, there was additional work for staff and the justices that needed to be done, and discussions discussions were unnecessarily delayed in some matters. 7, Justice Young asserts he is a rule of law justice. Judge for yourselves. In particular, look at the following cases. Lee versus McComb, a 2001 case. Cleveland Cliffs versus National Wildlife, a 2004 case. Michigan Citizens for Water Conservation versus Nestle, a 2007 case, in which Justice Young either authored or joined the opinion. Those cases had to be applied by the lower courts in the most recent case of Lansing School Education Association, teachers, versus Lansing Board of Education. Teachers had been denied rights to seek protection from assaultive students because the Lansing School Board refused to follow the law passed by the legislature that assaultive students must be automatically expelled. One teacher had a chair thrown at him, another teacher was hit by a student, and there were others. The lower courts found against the teachers because they, the lower courts, were required to follow the law created by Justice Young and that majority at that time that required them to do so. 4 judges at the Supreme Court this spring, those not appointed by Governor Engler, reversed and followed the rule of law, i.e., the law passed by the legislature. Justice Young was not among them. You should decide for yourself whether Justice Young is fit to serve on the Supreme Court. As for Justice Mary Beth Kelly, here are the facts. 1, she is a former law partner of Justice Bob Young. 2, she is from Wayne County. Should she and Justice Young be elected, all 7 justices would be from the Detroit-Lansing Beltway. That's 3 counties that cover 40% of Michigan's population. That leaves 60% of the population in the 80 other counties with no representation on the Supreme Court. 3, most important, it's plain that as Chief Judge of the Third Circuit Wayne County Court, Trial Court, Judge Mary Beth Kelly acted contemptuously and violated the rule of law, and her intentional contempt caused the whole circuit court to be found in contempt. She knowingly violated the rule of law and testified to that effect on the trial court. The contempt decision was confirmed by the Court of Appeals and the Supreme Court itself. Even Justice Young acknowledged that she, quote, made a mistake, close quote. I share these facts with you, and they are many others, for you to decide whether these are the kind of justices you want to sit on the Michigan Supreme Court, our state's highest court, the one that should be the most professional, the most to be able to be trusted, the most open, the most fair, the most dignified. Will they fulfill your expectations of an open and fair court? Would they fulfill the intentions, expectations, and the hopes and faith of our founding fathers? That's for you to decide.